Then welcome everyone. Good morning, good afternoon, or good evening, depending on where you are connecting from. My name is Natalie Welfens. I'm a postdoctoral researcher in the ERC RefMig project based at the Hertie School of Governance in Berlin. And I have the great pleasure to welcome you today to today's webinar on the right to work of asylum seekers and refugees, leveraging and litigating for effectiveness. Just for your information, we're recording the event, and this is a joint event of RefMig and the ASILE project, which is hosted by the Center for Fundamental Rights at the Hertie School, Berlin. A few notes on housekeeping before we actually start. Please turn your microphone and camera off during the presentations, unless you are the speaker, of course, but you're welcome to put them on if you want to pose your question yourself during the Q&A. We will have a short coffee and chat break around 4:50 Berlin time, where you're invited to just take a comfort break, get yourself a cup of coffee, and maybe some of the speakers want to stay online to chat a little bit informally. And now let's turn to our distinguished speakers of today. It's a real great pleasure to introduce them. I'll keep my introductions rather short, as there are also longer bios on the event page. Unfortunately, Dr. Lewis Turner from Newcastle University won't be able to join us today. He's sending his apologies. He can't join us due to sickness, but you are all very much welcome to check out his very exciting work in his publications. And we are happy that all other speakers are here with us today. We will start today's webinar with a presentation on the right to work of asylum seekers and refugees in international law, presented by Professor Cathryn Costello, who's co-director of the Center for Fundamental Rights and a professor here at the Hertie School and at the University of Oxford. And she will present together with Professor Colm Ó Cinnéide from the University College London. Their presentation is based on an ASILE working paper, which you can also find on the event page in the program. After that, we'll have Professor Jennifer Gordon from Fordham Law School in New York, who will talk on the right to work versus rights at work, centering decent work in refugee employment initiatives. And among her many publications, there are two that are very much on the topic of today: a 2019 ILO paper on refugees on decent work and a 2021 article on the international governance of refugee work in the context of the Jordan Compacts. Both publications can also be found on the event page. So after these two presentations, we'll have briefly time for Q&As. You can also just post your questions in the chat in a succinct form. And after that, in the second half of the event, we'll have two more presentations. We will resume around 5 o'clock with Professor Fatima Khan from University of Cape Town, who will speak on recent developments on the right to work in South Africa. And Professor Khan has also published very widely, but I would like to mention one publication, which is a co-authored chapter in the recently published Oxford Handbook of International Refugee Law on refugee naturalization and integration. And last but certainly not least, we have Professor Feline Freier from Universidad del Pacífico, Lima, Peru, who will talk to us about refugees, the right to work, and informal markets in Latin America. And Professor Freier has also contributed to the Oxford Handbook with a chapter on the evolution of safe third country law and practice. So without further ado, I would like to now give the floor to our first two speakers, Professor Cathryn Costello and Professor Colm Ó Cinnéide. Please, the floor is yours.
Great. Thank you very much, Natalie, and thank you to all of you for joining for this discussion. Let me begin by saying, as I share my screen for a moment, let me begin by pointing out that I perhaps am a small minority among you, because I am not a refugee law specialist. I am social rights, constitutional law, non-discrimination specialist. But I come to this from the experience of maybe 10 years of being a member of the European Commission on Social Rights, the body that interprets and applies the European Social Charter, the ECHR sister instrument that is supposed to protect social rights. And a constant issue for the committee in interpreting the scope of social rights was how should the social rights guarantees set out in the Charter, how should they apply to the situation of asylum seekers and refugees more generally? So it became a bit of a mini intellectual obsession of myself, and Cathryn and I ended up writing this paper, this ASILE paper together, which also, by the way, has another incarnation as a chapter in the Oxford Handbook of International Refugee Law. I'm going to be brief in this paper, as is Cathryn. We're going to take 5 minutes each, and we're going to outline basically the right to work of asylum seekers and refugees in international law. This right is quite squarely protected. The right to work is set out. You'll find it in the Universal Declaration of Human Rights, Article 23. Everyone has the right to work, free choice of employment, just and favourable conditions of work, and protection against unemployment. Note the wording, everyone. This is a universal human right. You'll also note that this right, which is often thought of as a sort of socioeconomic right, is actually more complicated in form than that. It's best understood as what we call in the paper a composite right, a right that, because it's concerned with different aspects of access to work, it cuts across the traditional divergence between civil and political and socioeconomic rights, and it has civil and political and socioeconomic elements. It also incorporates key elements from labour law, and indeed, as we'll discuss in a moment, it has a very, very substantial non-discrimination component. So it's a composite right, this right. It's protected in different ways across different human rights instruments. Some instruments just classify the right to work as a single instrument, as a single entitlement. Others divide it out with a right to access work, and then a right to fair and just conditions of work, a right to non-discrimination in work, and so on. The key point is that the essentials of this composite right to work are protected in multiple international human rights instruments. Our focus today is going to be on the one with broadest global reach and broadest scope, the International Covenant on Economic, Social and Cultural Rights, ICESCR, but we could also discuss elements of many other international human rights instruments, which also touch upon this right. And we'll discuss that if you want to in the chat. Now we're going to divide up this presentation, the brief time available to us as follows. I'm going to talk about the normative dimension of this right. What does international human rights law require of states by reference to the right to work as primarily protected by ICESCR and certain key regional human rights instruments? Cathryn is going to talk about how this normative content of the right to work can and is being leveraged by activists and other policy actors to try and improve access to right to work for asylum seekers and other refugees. In our discussion, you must bear in mind background context, which everyone tuning into this will be aware of, which is to say that there are substantial restrictions on the right to work of asylum seekers and other refugees across the world. Sometimes formal restrictions, simply can't work. Others, procedural restrictions, restrictions in substance, restrictions in form. You'll all be aware of that. We discuss it in detail in the paper. You are an audience who don't need to be told. Access to work rights is a fundamental challenge for asylum seekers and refugees across the world. The right to work has both instrumental and intrinsic value. It is instrumental value because it helps access social goods, helps social participation, but it also has intrinsic value because the act of work gives a certain degree of human dignity, as thinkers going back to Marx and even before him have recognized. This dual value of the right to work, as we call it, has been recognized by, for example, the Committee on Economic, Social and Cultural Rights in their general comment. It's an important point because, of course, states often say, well, you know, if we deny asylum seekers access to work, well, then there's not a problem here because we provide them with basic welfare support. But of course, the denial of right to work also constitutes, denial of the right to work takes out the intrinsic value of the right to work, the ability to sort of work, to labor with dignity in a social setting. Very briefly, let me set out the normative content of the right. Articles 6 and 7 ISESCR protect free choice of dignified labor and just favorable conditions of work, interpreted to require that decent work be available, accessible and acceptable. Okay. These commitments are often written off as soft, woolly socioeconomic rights commitments involving progressive realization, but actually once you start breaking down the content of these norms, they actually have both a minimum core, certain basic obligations upon states which are capable of immediate realization, but also have an enormously important non-discrimination and also programmatic elements, which we can discuss later on. ISESCR, zeroing in on the guarantees the right to work set out in ISESCR, you will see the key ingredients in the PowerPoint in front of you. And what's absolutely key to emphasize, as the Committee on Economic, Social and Cultural Rights has recently affirmed in its General Comment 23, the right to work protected in Articles 6 and 7 ISESCR is a right of everyone without distinction of any kind, with the committee specifically emphasizing asylum seekers and types of refugees. They also go on, taking account of the non-discrimination guarantees set out in the Covenant, that this right to work should be protected by states and conditions equivalent to the same protections for the right to work as nationals enjoy. Now, that's an interestingly high level of protection, higher, as we analyze in detail in the paper, than that's set out in Articles 16 and 17 of the Refugee Convention. We can discuss that in detail. There's been a shadow sometimes over this very broad sweeping normative guarantee of the right to work. Like sometimes some people interpret Article 2, subsection 3 of ISESCR, which says that states may impose restrictions on this right in the interests of their development. But actually, as we argue in the paper, much too much has been made of that. And so I want to emphasize this ISESCR guarantees this very broad general guarantee. Okay. Also, by the way, imposes certain obligations of international cooperation, which again discussed in detail in the paper. I also want to mention very briefly the fact that this right to work receives either direct or indirect protection through non-discrimination and privacy rights and other clauses of regional human rights instruments, in particular strongly enforceable human rights instruments, such as the Inter-American Convention on Human Rights and the European Convention on Human Rights. And it even receives a certain degree of indirect protection through EU law, as the recent Court of Justice decision in KS indicated. Now, none of these regional guarantees provide an unequivocal or universal guarantee of the right to work, but they all provide apertures or points of pressure through which legal and political activism can be mobilized to try and push for a widening of the scope to right of work as enjoyed by asylum seekers and refugees in any given national context. And on that point, I'll hand over to Cathryn.
Great. Thank you so much, Colm. I hope people can hear me, can they? Good. So as Colm so beautifully set out, and I should also thank him for the co-authorship of the paper and the chapter, which was a pleasure, and it was great to work with him. There are these apertures. So, you know, we find the right to work very clearly protected, for example, in the African human rights system, and very explicitly. And so there's an opportunity there, but we know that these legal opportunity structures are configured differently in different contexts. And often when we looked actually across some of the national case law, we found that more typically litigants tend to rely on their national Bill of Rights. And what we tried to do in that section of the paper and the chapter is really think about choosing a set of cases to examine where the relationship between international law and the national constitutional standards is differently configured. And in a way, what we found there was a little surprising. So I'm just going to give a very potted summary of the part of the paper that touches on this. The South African case is interesting, and we're honored that Fatima Khan is going to talk about that in more detail. But really the point that we make in the paper about the South African case is that, well, in the background in South Africa is the fact that asylum seeker status in South Africa is usually protracted. So the asylum system doesn't really reach swift positive decisions or at all often. So litigating the rights of asylum seekers has become hugely practically important. And the South African courts, although they could have relied more directly on international law had they wanted to, because that opening is possible under the South African Constitution, tended to focus on the right to dignity within the South African Constitution. Now, a dignitarian reading of the right to work could actually support the dual value of the right to work. So it could be about the instrumental value of the right to work and also its inherent value. But in fact, sometimes in this dignity case law, what we find is a focus on a minimum. So the idea that dignity simply requires that people not fall into extreme destitution. And so that's one of the limitations of the South African case law, significant as it is. And then, as Professor Khan, I'm sure will discuss, currently in South Africa, new legislation has been adopted, which really pushes back against this case law. So this is really a hot topic. The second set of cases, or the second case we look at, is Ireland, actually, where there isn't really much, there is a constitutional right to work. But again, it was litigated quite unsuccessfully for a time until relatively recently, where there was a very significant ruling on the right to work of asylum seekers. In the background there, I think also is, again, a significant fact about the legal opportunity structure, which is that Ireland hadn't opted into the relevant EU legislation, which would have at least provided that after a certain period of time, asylum seekers would have to be accorded a right to work. But this was relatively successful constitutional litigation around the right to work. And even though the Irish Constitution isn't all that friendly to international law, the case itself cites ISESCR and really takes into account this dual value of the right to work. We also, in passing, mention case law from Hong Kong and UK case law. And I think what that also tends to go in the direction of a right to work, but really a minimal right to work to try to ensure that people avoid extreme destitution. So a little bit along the lines of the Article 3 ECHR case law. So what we try to do with the selection of cases, but really it's open up for a lot more scholarly inquiry, is demonstrate that in different constitutional contexts, what you see this process of sort of co-creation of a human right to work, invoking international law and national constitutional standards. The second part of the that I wanted to conclude with, which is really just by way of setting up the remainder of the webinar, is that we also in the chapter try to open up a bit of legal analysis of the practices that we broadly called leveraging, which refer to transnational practices of trying to use pressure from donors or the international community, sometimes because they wish to contain refugees in the target states, but to encourage them to open their labor markets for refugees. The containment logic is writ large, particularly in the first one on the list, the EU-Turkey statement, but for all the downsides of it, this push to contain refugees in Turkey did actually coincide with some labor market opening. But I think our main message here is that actually when you look into detail, often what these kind of practices entail is actually offering refugees and asylum seekers the right to get a work permit, which is very different to actually realizing their right to work in that sense of a full right to decent work where they would have free choice of employment. And it also means that politically states have been able to get benefits from apparently offering the right to work, where actually what they're doing is inserting refugees within very restricted labor market structures where they have a migration status which ties them to a particular employer. And this, as we'll see, and we're going to hear from probably the leading experts on this topic shortly, in the Jordan Compact and the Ethiopia Compact is one of the downsides of these approaches. So in that part of the paper, and I'm going to conclude on this point, what we do is we set up a sort of framework to suggest a framework for a human rights analysis of these practices, which would think about decent work from the outset, also be attuned to the context in which informal work is so prevalent, and build in some safeguards, participatory safeguards, in particular considerations about the gender division of labor, which could inform some better design for these types of practices. So we're looking forward to hearing from the other experts that we've assembled on this topic and discussing this with you in a little bit more detail. But thank you very much.
Thank you both for kicking us off with a very interesting presentation. I'm sure that already gives us some food for thought and will connect very nicely to the next presentations as well. So with that, I'd give the floor to Professor Gordon, who I understand does not have a presentation, right? And we'll just present like that.
Not a slide presentation, no.
Okay.
Great, thank you. So Colm and Cathryn's discussion of the right to work for refugees and asylees in a formal sense raises the question of the kind of work we're talking about once the formal right to work hits the ground. And that's what I want to talk about in my presentation. And I want to focus particularly on refugees recognized by UNHCR rather than asylees, just for the purposes of these remarks. So by and large, refugee work programs over time have been characterized by what I would call refugee exceptionalism. That is to say, they create economic opportunities for refugees as a distinct group from economic migrants or local workers. And they do that through programs that have a humanitarian gloss or a development gloss, which are not cast as an intervention in the host country labor market, often for obvious political reasons. And in this mold, the most familiar forms of refugee economic activity have been crafting, farming, market activities, or cash for work payment for tasks performed in a camp setting. More recently, however, and Cathryn alluded to this at the end of her presentation, we're seeing programs that position refugees as waged workers in the context of host country labor markets. And that's something endorsed by the Global Compact on Refugees as well. Now, I said recently, but I should note that this isn't actually new. This was the model after World War I, when refugee resettlement was in the hands of the ILO. It was after World War II, with the signing of the 1951 Refugee Convention, that the ILO role was terminated and a bright line was drawn between refugees under the UNHCR and migrant workers under the ILO to some extent, and later the IOM. Now, the Syrian refugee crisis and the Jordan Compact that Cathryn referenced brought us what I would call a high concept model of waged work for refugees. Its idea was to incentivize export factories in the Jordanian garment industry to hire refugees by providing trade preferences for goods to the EU for goods made with refugee labor. In detail, it sought to place 150,000 Syrian refugees in Jordanian garment manufacturing in export zones, an industry known for low pay, poor working conditions, long hours, and sexual harassment, and largely staffed by migrant workers rather than refugees. That was initiated in 2016. We're now 5 years on. Despite over $1 billion spent by the EU and financial institutions, the plan, this aspect of the plan has failed, both because employers, that is to say garment manufacturers, rejected refugees as workers, preferring migrants who were fundamentally more controllable, and because refugees rejected the work because they felt they could not make a living for themselves in Jordan, given the pay and treatment in that industry. Today, less than 500 of the predicted 150,000 Syrians work in the Jordanian garment industry. Now, in 2016, we also saw the signing of the Ethiopia Jobs Compact on a much smaller scale. The goal of that compact was to do something similar, but in the Ethiopian garment industry for Sudanese, South Sudanese, Somali refugees, and so on in that country. And around that time, 2016, 17, 18, there was a lot of interest in this idea. So it was discussed, for example, in Bangladesh for the Rohingya. It was discussed in South America for Venezuelans, although never formalized in other contexts. In reality, though, the most common form of waged work for refugees is very low concept. Informal or partially informal work, frequently in sectors dominated by migrants and indeed by the refugees themselves prior to the formal program, but working informally. This was also part of the Jordan Compact. In addition to the 150,000 permits for garment work, the compact included 50,000 work permits for Syrian refugees to work in Jordan in a number of low-wage sectors that local workers had rejected. And these did have uptake. Nearly 50,000 Syrians used these work permits to work largely in agriculture and construction. Their status was formalized, but the wages and conditions of work did not fundamentally improve. And taken as a whole, the Jordan Compact illustrates the perils of a disregard for decent work in the context of refugee work or refugee self-reliance, as they're often described, initiatives. Without decent work as a central goal, the Jordan Compact ultimately concentrated some of the world's most vulnerable people in some of its least desirable jobs. And in general, too often, refugee work initiatives become what Georgina Ramsey has called humanitarian exploits, or as I quote, efforts to incorporate refugees into local economies that not only fail to resolve their displacement, but serve to exacerbate it, transforming refugees from recipients of humanitarian aid to highly exploitable workers. So what principles might guide the design of refugee work programs if their goal was not just to put refugees to work, but dignity and rights at work for refugees? And I want to focus on three things that I think need to change. One is the goal, one is the scope, and one is the governance. As to the goal, perhaps this is obvious, but a goal of refugee work programs needs to be explicitly decent work for refugees, on the theory that if refugees are really to become self-reliant, as the rhetoric goes, they need access to good jobs, not a seat at the world's cheapest sewing machine. And that includes decent pay and hours, as well as safety. And I would argue that there is a lot to be learned in terms of how to actually operationalize this from the experience of migrant workers and their advocates, despite the bright line often drawn between the two. So for one, refugees will need to be covered under the same labor and social protections as others in the labor market and have the same opportunity to voice and act on their concerns at work through trade unions. And refugee work programs will also need to avoid common traps that lead to exploitation in migrant labor programs. So to state it in the affirmative, work permission should be held by the refugee, not an employer sponsor. Work permission should be valid and mobile across firms and regions of the country. And work permission programs for refugees should respond to the particular vulnerabilities and strengths of refugee women. Those are three lessons taken directly from the experience of migrant workers and what's necessary to make migrant work programs less exploitive. Equally valid, I would argue, in the refugee context. So that's change in goal. Second, we need a change in the scope. Because decent work can't be achieved for refugees in isolation from other workers. A labor market is an economic organism. An intervention on behalf of refugees has to be structured as a part of efforts to advance decent work across the entire organism, because inserting a large group of new workers at the bottom of a labor market without sufficient attention to labor rights and standards for all workers in that market has damaging impacts on those already employed there or hoping to find employment. What this means is that refugee waged work programs can't be special humanitarian initiatives, but instead have to be integrated into decent work efforts in the host country overall, including attention to informal as well as formal sectors. And then finally, and maybe most extensively, we need changes in the governance of refugee work programs to ensure that decent work is a focus for refugees. From conception of such programs through their implementation is going to require a shift in how these programs are planned and how they're implemented. At the level of international governance, we need labor rights-oriented players at the table from the beginning. To date, humanitarian development and finance organizations have led the charge on refugee work, with minimal consultation with international organizations knowledgeable about labor markets, labor migration, and workers' rights, which of course reflects the division between refugees and migrant workers that was put into place, as I referred to earlier, with the 1951 Refugee Convention. This division has become increasingly problematic as international actors have sought to move refugees into the employment arena. The UNHCR has many critically important competencies, but it lacks the necessary tools and mandate to make decent work a central focus of refugee work initiatives. That's because its primary mission is focused on refugees, humanitarian, and service-oriented. And these things have a series of ramifications when we turn to work. I'll just mention three. The UNHCR is drawn to framing refugee employment as an opportunity for firms to take voluntary action for the public good. Yet again, a labor market is not a charity, it's an economic system. And most companies have failed to deliver even on the very modest refugee employment commitments that they've made. Second, the UNHCR's focus on subsistence level refugee relief, a necessity given the dire circumstances of many refugees, has resulted in programming that tends to view any job as a desirable job, rather than assessing options from a decent work perspective. And finally, even if we were to fix the first two orientations, refugees will remain the sole beneficiaries of the UNHCR's protection mandate. A siloed approach to work for refugees fails to take into account the labor-related concerns of others who are similarly situated. So the primary affirmative change here would be to include a more prominent role for the ILO and for global union federations in the planning of refugee work initiatives at the international level, in recognition of their extensive expertise with the establishment and enforcement of labor standards for all workers. More briefly, at the level of national governance, we need parallel changes. And this means at the host government level, a featured role for the labor ministry, for example, not just the foreign ministry or the ministry in charge of humanitarian affairs. This would allow planners to focus on, for example, the training and deployment of the labor inspectorate in informal sectors, or on creating space for genuine freedom of association, to name two host country policies that are intimately tied to decent work for refugees and others. And finally, at the level of the ground where the workers work, refugee work programs need governance mechanisms that involve the workers themselves in design and enforcement. And here I would include active roles for migrant and informal worker organizations, as well as for refugees' own organizations to the extent that they exist. There's a lot more to say, but I'm going to stop there. I know we're going to have a comments and Q&A session right now, and so I think this is a good place to pause.
All right, then I would say welcome back to the second half of this webinar, where we will continue with a presentation by Professor Fatima Khan from the University of Cape Town on recent developments on the right to work in South Africa. Fatima, the floor is yours. If you're already back, there you are.
I'm back. I'm back. Thank you very much, everybody, for inviting me to this to participate in this workshop today. I will be presenting on developments in South Africa, but before I do so, I'd like to share with you that it is a public holiday in South Africa today. Today is a day that have been set aside for municipal elections. And believe it or not, I'm sure you will believe this, one of our newly established parties announced that if the results of the election is announced at 9 o'clock in the morning to say that they have won the elections, you can rest assured that by 3 o'clock in the afternoon, there will not be a single refugee business running in this country. So of course, that's not going to happen. It can't happen. Our law does not allow it. But just so that you know that such is the sentiment in the country. And that may be one small party that made, or newly established party that made that statement. But my sense is that a large number of people in South Africa would have it that way. The refugee legislation, of course, does not allow that kind of approach. The refugee legislation is progressive, it is generous, it was introduced post-apartheid, and it does reflect the country's transition to democracy and its commitment to human rights. It evidently grants the refugee whose claim for asylum has been adjudicated successfully the right to seek and take up employment in South Africa. Section 27F of the Refugees Act states that the refugee is entitled to seek employment. However, the Act makes a distinction between a refugee and an asylum seeker. And prior to the amendments, the Refugees Act stated that the Standing Committee of Refugee Affairs, and this is an administrative body established in terms of the Act, must determine the conditions relating to work or study under which the asylum seeker permit may be issued. The Standing Committee at the time, the decision was to prohibit asylum seekers from accessing the right to work for their first 180 days. But this was successfully challenged in the 2006 Supreme Court of Appeal case of the Minister of Home Affairs and another versus Mrs. Ochanuka and another. And as a result of that judgment, all asylum seeker permits have since been endorsed with this right to work and study. And when this general prohibition on the asylum seeker's right to work was challenged in the court, the Standing Committee raised a series of arguments in favor thereof, such as the potential for fraud or the protection of national applicants, that the refugees could, or the asylum seekers could approach charities for social assistance, could approach the UNHCR, social implementing partners, but the court invalidated them and called the general prohibition on employment, and I quote, a material invasion of human dignity that is not justifiable in terms of the Constitution. Of course, the court rightly stated that dignity applies to everyone in the country, and it stated that dignity has no nationality. But the court made several assertions on the link between the right to dignity and the right to work. And with regard to financial independence, the court stated that limiting the right to work is more than limiting self-fulfillment. It constitutes a restriction upon the asylum seeker's ability to live, and I quote, without positive humiliation and degradation. It also stated that the right to human dignity protects the freedom to engage in productive work because it satisfies the human need for a meaningful life, even though it is not required in order to survive. And because South Africa offers no state support to applicants for asylum, a person who is destitute will have no alternative but to turn to crime or for begging, and I quote again, for foraging. The court stated that the deprivation of the freedom to work assumes an entirely different dimension when it threatens to positively degrade rather than merely inhibit the realization of the potential of self-fulfillment. But having said all of that, the court also recognized that the core fundamental rights, such as dignity, may be limited in certain appropriate circumstances. In this case, the right to work may be limited, but not when employment is the only reasonable means for the person's support. And the only way the standing committee could therefore make the decision whether to endorse a permit for the right to work or not was to conduct individual assessments or to produce guidelines. And at the time, in 2006, the standing committee found that to be too onerous, too problematic, practically impossible. At the time, there were only 3 members to the standing committee, and it opted to endorse the right to work on every single asylum permit. And that was the situation up until, it's still in existence up until today. But the amendments that have been signed into law, the 2017 amendments that were signed into law, and that was supposed to become operational on the 1st of January 2020, states otherwise, right? The amendment, like the previous act, also confers the duty on the standing committee to determine conditions of work and study. But in addition to that, it has outlined a number of preconditions that the standing committee must uphold. Number 1, the standing committee, before it endorses any asylum seeker visa, must undergo an assessment of the asylum seeker's material conditions. And the right to work will be granted if and only if the applicant is unable to sustain themselves and their dependents for a period of 4 months. And if neither the UNHCR nor any other charitable organization or person has made the applicant an offer to provide them with basic shelter and necessities. And then in addition to these preconditions, you also have some formalities. The right to work will be endorsed. If the right to work is endorsed on the permit, the employer must provide the Department of Home Affairs with a letter of employment within 14 days. If this does not happen, the employer will have to pay a fine of up to about 20,000 Rand. That's about $1,500. And if the asylum seeker is unable to find work within a 6-month period, then that right will be revoked. There's also very little clarity on the nature of the assessment process. Some very important details remain unstated. For example, what is the threshold for the 4-month sustenance? Who bears the evidentiary burden to prove that the asylum seeker cannot sustain him or herself or their families? How is this supposed to be determined? Is it determined by the asylum seeker, by the family, by bank statements? It's completely silent on all those issues. But we can glean 2 very significant observations from this amendment. Number 1, the right to work is treated as a last resort. And from all the presentations this morning, it is all of those presentations, it is a last resort. It can only be granted when the asylum seeker has no other means to survive. And secondly, the formal employment of the asylum seekers is to be strictly regulated on the employer side. So it exposes the asylum seeker to exploitation by the employer, but it is also cumbersome for the employer to do, and it's employers may just deem asylum seekers to be a liability and refuse to employ them. So can we challenge these amendments by considering the existing jurisprudence? In my opinion, the Wachanuka case provides an important platform on which to challenge these amendments. Enforcing a ban, and this is what is required, enforcing a ban that requires a person to rely on charity, I argue would amount to humiliation and degradation, which clearly violates the constitutional right to dignity. And although Wachanuka was conservative in its conclusions, only rejecting a general prohibition on work and not endorsing a right to work, its arguments with regard to dignity and financial independence should, in my opinion, lead to the conclusion that the amendments are unjustifiable. And as I mentioned earlier, the endorsement of the right on the permit the permits are currently endorsed with this right because of the practical inability of the standing committee to do this one-on-one assessment. In my opinion, this practical challenge persists and it's not likely to happen. I think the standing committee now consists of maybe 5 or 6 members. But having said that, I do believe that we can go a step further than Wachanuka. Even though the amendment assures the ability to provide for a living is fulfilled by either the asylum seekers themselves or by a charitable organization before they limit the issue of a work permit, the right to work interpreted in compliance with the Constitution, in my opinion, encompasses more than just shelter and the bare necessities. So we can, even though, and I realize, as Cathryn said earlier, the South African judgments are largely focused on South Africa's own Bill of Rights, but we can strengthen our case even by going back to the Bill of Rights, by arguing what the right of work actually encompasses. But I do believe, as Cathryn noticed, that we should go outside. We should go outside of the Bill of Rights. We should look at international human rights law and international refugee law, because after all, our Constitution provides that the court must consider international law in the interpretation of the Bill of Rights. So, as valuable as the human rights jurisprudence to frame the issue of dignity, frame the issue in terms of dignity and vulnerability, I do believe this framing distracts from the fact that asylum seekers already have the right to work in terms of convention. Refugee status determination, we are all aware, is merely declaratory. And among the population of asylum seekers are refugees whose claims have not been formally recognized. So the category of an asylum seeker is, from the perspective of the convention, a fiction. And since 2006, there have been a plethora of empirical studies in South Africa with findings of prejudice suffered by refugees living in a limbo state as asylum seekers for 10 years or more. I don't see this backlog changing overnight, not because of the amendment or because the government is intending to process asylum seeker applications at processing centers. I don't see any of this speeding it up. So I think this is something that we should bear in mind when we go back to court. As mentioned earlier, these amendments, even though they've become operational, they've not been implemented yet. The asylum system has not received a single new asylum applicant, new applicant since the pandemic. And we are assuming that if the amendments become operational, that it will be prospective. And however, we can't rely on that. But should all existing asylum seeker permits be work permits be withdrawn, it is a technicality and it is a challenge that we are most likely to win. And as you can see, because there hasn't been implementation of this yet, there have been a lot of ifs and hows at the moment. However, we are ready to litigate on this issue, and we are far more ready to litigate on this issue than we were in 2006 with the Waterlooker case. Thank you very much.
Thank you, Fatima. That was really interesting, and I'm fascinated by this vocabulary of dignity on the one hand, and then all these restrictive measures on the other hand. I'm sure we can talk more about this in the Q&A with, but now I will hand the floor over to Professor Feline Freier for the last presentation for today. Please, Feline.
Thank you. I'm just struggling to upload the presentation because I'm on a new laptop. Let me just see. Yeah, 1 second. Okay, it's asking me to actually quit Zoom and reopen. Would it be faster, Natalie, if I quickly send you the presentation?
Yeah, send it to me and then I'll put it up in the meantime. And if you like, you can already start presenting.
Yes, so I will just see that you're here. So sorry for this. Thank you so much, Fatima, for your presentation. I will be trying to keep my presentation short in the view of the little time we have left, but we'll actually see quite a lot of parallels once I start talking about the Latin American case in a second. I'll just quickly send the presentation. Okay. Have you received it, Natalie? Yes?
I'm on it.
Okay, super.
I'll put it up.
So I will be talking to you about refugees, the right to work, and the link to informal markets, largely informal labor markets in Latin America. And what I wanted to do, and hopefully while Natalie can pull up the slides, just a very brief overview of what I'm going to do. I'll talk a little bit about how Latin America compares in the case or the figures I'll present to the European Union in terms of legal good practice in refugee protection. And then come to the Venezuelan displacement crisis as a case study to actually see in how far these legal good practices are implemented or have any kind of importance in practice. I will talk about labor informality, labor exploitation, and integration, and then end with some final reflections of what all this might mean. I'm a political scientist by training, so I often work with legal scholars, and I think obviously the two disciplines are closely related. So if you want to skip to slide 3, Natalie, what we see, thank you so much, is a comparison. Yeah, there we go. Of legislative good practice between the European Union protection standards and 19 countries in Latin America. And what you see basically at 0, right, which would be basically the invisible line in the middle of these different lines, right, is the European protection standard, once in terms of integration and once in terms of original general legislative good practices. We based this analysis together with Jean-Pierre Gauci on the legislative good practices that the UNHCR had identified for the Latin American region. And basically, the only thing I wanted to show here is that in the area, the specific area of integration, Latin America indeed is exceptionally progressive. So basically, it's probably hard to see, but all the lines that show towards the right, are countries that in their legislation are more progressive, guarantee more rights than the European Union, right? And what we see here that this is the case for more countries in Latin America in the area of integration. This is the left figure in comparison to the overall legislative good practices. So if we can continue with the next slide. Another thing that we really need to understand to understand what is going on in terms of labor rights and labor integration in Latin America is that the Latin American region has an expansive refugee definition. This expansive refugee definition goes back to the Cartagena Declaration of '84, but it has since been incorporated in the national laws, so in the national legislation of basically all Latin American countries. And here the figure is taken from Omar Hamad Gallego's work, right? And you see from the 1990s, basically the bluer, right? The more states turn blue symbolizes the number of states that have incorporated Cartagena in their national legislation. This definition includes people who have fled their country because of their lives, safety, or freedom have been threatened by generalized violence, foreign aggression, internal conflicts, massive violation of human rights, or other circumstances which have seriously disturbed public order. So it is very clearly a much broader definition of who should be considered a refugee than the 51 definition of refugee. And it includes situations, right? So it doesn't focus on personal persecution. It includes situations which lead people to leave their countries or flee their country. Next slide. The right to work has been incorporated for refugees in all Latin American countries, with the exception of Cuba. And this right has also been extended to asylum seekers in a majority of countries in Latin America. Another legislative good practice we identified with Jean-Pierre Gauci was the swift validation of foreign degrees, which in practice is something that is very important for the effective formal labor integration, especially of highly skilled, displaced populations. And this is a good practice that is found in the laws of Argentina, Brazil, Chile, Ecuador, El Salvador, Mexico, and Paraguay. Next slide, please. So how does all this, right? So this exceptional, maybe as the UNHCR itself has stated, and this is how we start the paper, which is available in Refugee Survey Quarterly with Jean-Pierre, the UNHCR itself, at least before the onset of this Venezuelan displacement crisis, called Latin America the avant-garde of refugee protection. They said Latin America really has the very best laws in the world. It has surpassed the European Union in terms of legislative good practices. What happened with the onset of the Venezuelan displacement crisis? Just to give you very brief context, since 2015, close to 6 million people have left Venezuela, and the vast majority in neighboring countries in South America. Next slide. What is the context of this displacement? It is certainly economic. So these figures, I'm not an economist, probably few of us are, but an inflation rate of 1 million%. What it means in practice is that whether you worked in Venezuela or not didn't make a difference in terms of the money you had to spend on food and other essential goods, unless you received remittances in US dollars from abroad. The Economist has called the Venezuelan economic collapse the worst outside of war in decades in 2019. I should probably skip this, but these are some figures that are just, they really show the scale of this economic collapse and the humanitarian crisis that went along with it. So 87% of the population already in 2017 lived in poverty. 90% could not afford children's daily meals, and something that as a mother, like really gets to me, this figure, and this is 2017. We don't have reliable data anymore. The situation has only gotten worse. Already in 2017, 33% of children showed irreversible mental and physical development delays. We had the political protests, we had deaths, casualties, illegal arrests, and disappearances. So very clearly, and this is something that legal scholars have analyzed, I've worked on this as well with dear colleagues in the region, the Cartagena refugee definition very clearly applies to the situation, not only based on the data we have on the crisis, but based on what states and the Organization of American States themselves have said and how they have pronounced themselves regarding the crisis in Venezuela. So in short, Venezuelan displaced people should be recognized as refugees. Next slide, please. I won't go through this in detail. You see a lot of text, and the point here is that there were myriad policy reactions, but only very few Venezuelans have been recognized as refugees. In Mexico and Brazil, Cartagena was applied to a couple of thousand, 10,000 people, but that was really the exception. There were two big reactions. Argentina, Brazil, Uruguay extended unilaterally a regional visa that allowed Venezuelans to work, because this is what we're interested in. And then many other countries, especially in the Andean region, developed these ad hoc special visas, migratory visas, that did extend the right to work, but they were always time limited. Colombia, no, maybe some of you have heard about the exceptional move to regularize, right, the majority of Venezuelans in the country earlier this year. They are not given refugee status. In Colombia, they're given a special protections, a special migratory protection status, right? I cannot go into details. We don't have the time. This move has been welcomed and celebrated by international organizations. It has also been criticized by many activists and legal scholars precisely because it falls short of the protection that would be granted given refugee status. In Peru, and I'll mention this because I'll go into a little bit more detail in the Peruvian case, if time permits. I'll try to be really fast. Different temporary migratory statuses and an ongoing migratory regularization program, which is currently taking place. Next slide, please. What this has led to, no, and this is also reflected in the language and in the knowledge production of international organizations, including the UNHCR, is that we are not talking about over 4 million refugees in Latin America. We're talking, and here you see the red line, which has absolutely exploded in the figure on the left. The UNHCR itself is talking about Venezuelans displaced abroad. What we should see is really the spike in blue, no, in yellow, sorry, at the very least, a spike in asylum applications. We haven't seen that, right? So there's a very interesting correlation, something that colleagues and I have been studying. Why are Venezuelans not applying for refugee status? They're only doing this in Peru. So in Peru, we have 500,000 asylum seekers, Venezuelan asylum seekers. And very similar to the South African case, collapse of the asylum system. I think we have roughly 3,000 recognized refugees, 500,000 asylum seekers. What is happening with these in terms of labor rights and labor integration? Next slide. Peru's economy, we have Peru on the far right, and I'm sorry I cut off the percentages, is almost 70% informal, right? So we see this throughout the region, but in Peru it's almost 70%. Yeah, this is a very different context we need to take into consideration if we want to understand the right of asylum seekers and refugees to work and what is happening in practice. Next slide, please. So unsurprisingly, perhaps the vast majority of Venezuelans work informally, right? We have different surveys that were conducted. We conducted a survey ourselves, and roughly 90%, yeah, work in the informal sector. This was pre-COVID. The data I'm citing now was February 2020. What we do see is that there is a lot of confusion and that there is no clear connection between having one legal status or another and having legal work. We see some evidence, and here I'm sorry I only had this graph in Spanish because I didn't produce it myself, but it's based on research that we conducted at the Universidad del Pacífico with a colleague. In blue, you see Venezuelans with some kind of regular status, including both a migrant visa and asylum seeking card or status, and in red, Venezuelans with irregular status. And what we see in the first three columns is that having no regular status at all increases labor exploitation. What we see here, I'll quickly translate, is not having, like, being in a dependent labor relationship but not having no contract, having not been paid for their work, and working excessive hours. And this is something that came up in many of the interviews we have conducted over the last couple of years, is that something that asylum seekers were very upset with was not necessarily having the right to work legally or not, but the kind of labor exploitation that they experienced and practiced. And here very clearly their vulnerability and their need to work, their need to send home remittances to make sure that loved ones survive in Venezuela, are being exploited by Peruvian employees in practice. And since the labor market is so informal and there is so little regulation in general, right, this just applies to Venezuelans who are in an especially vulnerable situation, much more than to Peruvians themselves. Next slide, please. I also chose this quote because it really summarizes what we found in many of the interviews. So here Leslie told us she doesn't really want to be a refugee, right? Because the problem is that even though she has a cabinet, so she has an ID, a paper ID that shows that she is an asylum seeker, this has not helped her in practice. Yeah, she felt that she and many others felt that no one knows what an asylum seeker is. Many employees don't know what a refugee is. So she doesn't feel that having asylum seeker status has actually given her legal status. So she says, I don't really want to be a refugee. I want to be able to opt for a legal document. I feel like a prisoner. My situation is uncertain. What does this refugee card allow me to do? What does this refugee card allow me to do? To stay here and then not to be approved for refugee status? We need answers. So we really found a lot of lack of knowledge about rights, both by asylum seekers themselves and by employees, which hugely limits their formal integration, right? We need to wrap up. So here in the table, what I wanted to show is the impact of COVID-19. And basically what we saw was a lot of increased vulnerability, lost jobs, increase in informal labor. And this is the last thing I'll point out here, is that, again, it seems that asylum seekers do have a much larger probability to have formal employment than do other groups in Peru, either without any legal status or with one of the migratory visas. Let's sum up. So what we have found is that of course, there are legal guarantees on the books, but they're not implemented in practice. We see this with the lack of application of Cartagena. These largely, I mean, again, it's really hard in a European context maybe to imagine the 70% informal labor activity in Peru, or economic activity in general in Peru, really hinders formal employment, especially for displaced populations that are more vulnerable and more need to take up any kind of employment. I didn't get into the taxation. That's another legal barrier really to formal integration, because Venezuelans would have to pay 30% of tax in the first year of legal employment. There's a lack of knowledge about rights that hinders formal integration. Lack of knowledge both amongst the asylum seekers, the displaced population, and employees. Of course, COVID-19 exacerbated these socioeconomic vulnerabilities. And what we did find, this correlation between asylum seeker status and improved formal labor integration, is something we're currently exploring deeper. We're still cleaning data because of this problem with lack and confusion about what kind of status they actually have. Very often they say, oh no, I have refugee status, but they're actually asylum seekers. So we're having a problem with the data there. But we really need to understand, where does this correlation come from? Is it really that having this asylum seeker status gives you, more leverage to exercise your rights? Or is it that it is people who are more informed already, right? And have maybe higher socioeconomic status, who both have asylum seeker status in Peru, and also have had more success in their formal labor market integration. So thank you, and I look forward to questions and comments.